Today's date and time is August 5th, 2011. It is 2:22 p.m. Today's business class lesson is called Non-Competition Clauses in Employment Contracts. In employment contracts, non-competition clauses are one form of agreement that places restriction on an employee conduct after the employment is over. Other restrictions on employees' post-employment conduct can include confidentiality or non-disclosure agreements, which constrain the employee from divulging or using certain information gained during his employment, and non-solicitation agreements, which forbid an employee from soliciting the employer's employees, clients, or customers. In many cases, employees sign all these forms of post-employment restrictions. In others, the post-employment restriction may reflect just one or two of these forms of restraints. Restrictions on competition work a greater hardship on an employee than on a person who has sold a business. For this reason, courts tend to judge non-competition clauses contained in employment contracts by a stricter standard than they judge similar clauses constrained in contracts for the sale of a business. In some states, statutes limit or even prohibit non-competition clauses in employment contracts. In others, there is a trend toward refusing enforcement of these clauses in employment contracts unless the employer can bring forth very good evidence that he has a protectable interest that compels enforcement of the clause. The employer can do this by showing that he has entrusted the employee with trade secrets or confidential information, or that his goodwill with near permanent customer is threatened. In the absence of this kind of proof, a court might conclude that the employer is just trying to avoid competition with a more efficient competitor and refuse enforcement because there is no legitimate business interest that requires protection. Furthermore, many courts refuse to enforce non-competition clauses if they restrict employees from engaging in a common calling. A common calling is an occupation that does not require extensive or highly sophisticated training, but instead involves relatively simple, repetitive tasks. Under this common calling restriction, various courts have refused to enforce non-competition clauses against salespersons, a barber, and an auto trim repair person. In the following NASC service case, the court determines whether to enjoin employees from violating their non-compete agreement. NASC Service Inc. versus Jervis, 2008, United States District LEXIS 40502 US DIST CTD NJ 2008, New Jersey 2008. Gary Russell began running a stock account program in 1969 and over the years grew his business into a large organization. NASC Service, which does business as MLS Camps, NASC Services and Russell, the plaintiff, operate soccer camps and provide soccer instructions to youth throughout the United States. The New York, New Jersey area is one of their most active regions. In this area, plaintiffs provide soccer camp service to roughly 185 soccer clubs in the past year, accounting for approximately $1.5 million in annual revenue. David Jervis, Adrian Moses, Stephen Jones, Simon Barrow, Benjamin Moffat, and Simon Nee, the defendants, are citizens of the United Kingdom and have played, taught, coached, and worked in the soccer industry most of their lives. The plaintiffs hired them to provide service for its soccer camps in the New York, New Jersey area. Each of the defendants entered into an employment contract with the plaintiffs. These employment contracts all included three relevant covenants: a covenant not to compete with the plaintiffs, a covenant not to solicit the plaintiffs' customers, and a covenant not to disclose the plaintiffs' confidential information. The plaintiffs placed the defendant in a position in which they were responsible for developing and maturing the plaintiff's relationship with customers in the area. Some of the defendants were stationed in Red Bull, New York, a soccer organization in Secaucus, New Jersey, to which the plaintiffs provided soccer camp services. Although defendants worked at the Red Bull facilities, they were the plaintiffs' employees. Between August and November of 2007, the defendants separated from the plaintiffs and assumed positions with the Red Bull, where they helped Red Bull launch soccer camps in the New York, New Jersey area in direct competition with their former employer. Though their specific reasons for leaving the plaintiffs differ, defendants also all wish to distance themselves from Russell, MLS campus owner, because of alleged mistreatment, deception, bullying, and abuse. Plaintiffs allege that since defendants left their employment with plaintiffs have experienced an immediate drop in customers in the New York, New Jersey area. They filed a motion for a preliminary injunction to prevent the defendants from violating the non-competition, non-solicitation, and non-disclosure clauses of their employment contracts. Kavanaugh, United States District Judge Kavanaugh. An employer's ongoing professional relationship with its clients is generally recognized as a legitimate business interest, which may be protected through a restrictive covenant. Every employer has a patently legitimate interest in protecting his trade secrets as well as his confidential business information, and he has an equally legitimate interest in protecting his customer relationships. Plaintiffs argue that the covenants are unreasonable both as to duration and direct and geographic extent. Plaintiff soccer account business is nationwide, with special concentrations in the New York, New Jersey area. Furthermore, a 2-year limitation is reasonable, according to defendants. However, the non-competition clause appear to be unreasonable because they are unnecessary to protect plaintiffs' legitimate business interests. Defendants provide no unique service, nor possess any extraordinary skills that could harm plaintiffs if they continue to work for the Red Bull or for any other employer in the soccer industry. Under Connecticut law, it would be an extraordinary stretch to extend mandatory injunctive relief under these circumstances. Plaintiffs nonetheless claim that the non-competition clauses must be enforced because defendants possesses allegedly confidential information concerning plaintiffs' methods of teaching soccer. Plaintiffs have no legitimate protectable interest in preventing defendants from continuing to teach children how to play soccer. In the course of their work for MLS Camp, defendants were not exposed to information that represents a trade secret. Their jobs require them to coach, teach, organize, sell, and manage your soccer camps. There is nothing confidential about how to teach soccer. Moreover, the secrets of Russell's allegedly proprietary strengths-based coaching programs are readily available to anyone. For a nominal fee, anyone can sign via one of Russell's websites to purchase all the materials necessary to master Russell's program. Russell's teaching methodology is nothing more than a collective of practices obtained from a variety of public sources. Likewise, plaintiffs' clients list constitutes nothing more than names of area soccer clubs who might be interested in youth programs, clinics, or camps for children in their programs. It appears likely that plaintiffs' list could be easily replicated from the vast array of information available via the internet. Furthermore, plaintiffs have not submitted evidence that defendants misappropriated confidential or proprietary information. Defendants claim that they have not divulged any information to Red Bull that they acquired from plaintiffs and that they have no intention in doing so. Likewise, defendants claim that none of Red Bull's employees have asked them to disclose any plaintiff's information. There are strong public policies reason for supporting non-competition agreements. Such legal enforceable agreements make it possible for an employer to hire and train employees, to entrust them with responsibilities, and to work with them in developing marketing strategies, secure in the knowledge that they will not, having gained these competencies, take them to a competitor's establishment and turn them against their former employer. Thus, judicial enforcement of non-competition provisions of employment contracts serves the public interest by promoting stability and certainty in business and employment relationships. In the current case, however, the balancing of the equity support denial of plaintiffs' application for injunctive relief. If plaintiff's application is granted, defendant will be forced to stop working for the Red Bull and be barred from working for any comparable business in any capacity in any part of the world. 5 of the 6 defendants will also be forced to leave the United States because their visas depend on their employment. This would create an oppressive and unfair scenario for defendants. Motion for the preliminary injunction denied in favor of the defendants. That is today's business class lesson. Hope you enjoyed it. Hey.